Hello all, hope you're well. So, does Haste Limited or Churchill Recovery Solutions even have legal standing to apply for a warrant of entry, and why this matters? By the way, none of the following information should be construed as legal advice, for it is not. Let me tell you something few people know. Every month across the UK, thousands of court warrants are being issued. Warrants that let strangers drill your lock, enter your home, and interfere with your gas or electricity supply. But here's the question. Do the people applying for these warrants even have the legal right to do so? Two names come up a lot: Haste Limited and Churchill Recovery Solutions. This video will explain why these companies may have no lawful standing at all, and why that matters for you and your rights. 1. What is a warrant of entry? A warrant of entry is a legal order that gives someone permission to enter your property, even without your consent. These warrants are most often used by energy companies, but they must follow the law exactly. You see, forced entry into your home is a serious act. That's why Parliament passed a law to limit who can request it. That law is called the Rights of Entry, Gas and Electricity Boards Act 1954. 2. What does the law say? Let's look at Section 2 of the 1954 Act. It says, quote, "A Justice of the Peace may issue a warrant authorizing any officer or employee of the relevant electricity or gas board to enter the premises." End quote. The key words are officer or employee of the board. Today, the electricity and gas boards have been replaced by licensed energy suppliers. These are the companies regulated under the Electricity Act 1989 and Gas Act 1986. That means the only people who can apply for a warrant are the supplier, the operator who holds the energy license, or an employee of that supplier. Not just any company, not a third party, not a contractor, and definitely not Haste Limited or Churchill if they are neither the operator nor an employee. 3. Who are Haste Limited and Churchill Recovery Solutions? Haste Limited and Churchill Recovery Solutions are private companies. They are not energy suppliers. They are not listed as holding any license from Ofgem. And unless they can prove they are direct employees of a licensed operator, then under the law they have no standing to apply for a warrant. Yet they are doing it all across the country. And courts are rubber stamping these applications day after day. That's a problem. 4. What does the court need to check? According to the Magistrates Court Act 1980, a court must be satisfied that the person applying has a lawful right to do so, and the entry is necessary for the purposes of the supply, and access has been refused or is not possible. But if the applicant isn't lawfully qualified under the 1954 Act, then the court has no power to issue the warrant. As Lord Denning famously said in Lazarus Estates Limited v. Beazley, 1956, fraud unravels everything. If a company misleads a court into thinking they have standing when they do not, the warrant is void. 5. What if this has already happened to you? So what if someone has already entered your home? If they used a warrant obtained by someone without standing, then what happened may be unlawful entry, trespass, criminal damage, abuse of process. You can take action. You could start by requesting a copy of the court file. you have the right to see who applied for the warrant, what they told the court, and whether they claimed to be the operator or an employee. Then issue a lawful notice. Ask them to prove their standing. Ask the court why it issued a warrant in apparent breach of Section 2 of the 1954 Act. 6. Can they apply just because you didn't pay a bill? Another big myth, that non-payment of a bill means they can get a warrant. Wrong. The 1954 Act does not allow forced entry simply for debt collection. Warrants are only permitted if it's necessary for supply, inspection, maintenance, or meter replacement, and only if access was refused. If the purpose is just to punish or press you over money, then the warrant may be an abuse of law. 7. What to ask if you get a threatening letter. If Haste Limited or Churchill sends you a letter, here are questions you could ask. 1. Are you the licensed NG operator? If so, provide the license number. 2. Are you directly employed by the operator? If so, please provide written proof of employment, including the name of the operator, your job title, and evidence of current engagement. 3. Who authorized this communication? 4. What law gives you the right to threaten entry? 5. Are you aware of Section 2 of the Rights of Entry Act 1954? If they can't answer or avoid answering, you have reason to challenge their authority. And remember, the civil procedure rules require all parties to act fairly and lawfully. Also be alert for other red flags. Use of the occupier on letters or court applications. This is not a lawful substitute for naming a real person, especially if the applicant knows who lives at the property. Use of P.O. box addresses by companies like Haste or Churchill. This can conceal their true location and make accountability harder. Under court rules and basic fairness, a party making a legal application should be clearly identifiable and contactable. These details matter. They can indicate a lack of transparency and possibly even a breach of due process. 8. Final words. The truth is this. Thousands of homes are being entered based on warrants that may be unlawfully obtained. Haste Limited and Churchill appear to be acting without clear legal standing. The courts are failing in their duty to properly check applications. And that means it's up to you to know the law, ask questions, and stand firm. Because your home is not a target, it is your sanctuary. And no one, no matter how official they sound, has the right to cross your threshold without lawful authority. Share this message. Help others understand their rights. And if you've been affected, don't stay silent. Lawful remedy begins with lawful knowledge. Stay tuned for the public notices served on the court manager at Birmingham Magistrates Court, which is the main venue for Haste Limited, and also the court manager at Swansea Magistrates Court, which is the main venue for Churchill Recovery Solutions. Please like and subscribe if you found this information beneficial. At Fraud Unravels All, 22nd of May 2025. Take care. See you soon.